Okay, welcome everyone, and thanks for attending Business Immigration Law, a primer for those who hire, manage, and recruit foreign talent. I always enjoy giving this presentation because it's nice to give people a broad overview of the area of business immigration. And by business immigration, we mean not family-based or asylum or removal or those areas, but immigration when it is involved in the context of a company that's looking to hire talent, a company that's making sure that its workforce is authorized to work in the United States. So it's both getting people in the door so that they can work for you, and then also making sure that your system that you have in place as an employer is complying with the immigration laws of the United States. As it says on the program, I'm Ben Curtin. I've been doing immigration law for around 19 years. I hate to admit, I can't believe it's been that long. And obviously there's been lots of changes, and certainly could be a lot more interesting changes coming up as we go along. And maybe if we have a little time, we'll touch upon those changes going forward. Right now, I guess just as an overview, it seems like we're going to be keeping most of these categories, if not all of them, that I'm speaking about. Even after 9/11, all these categories that I'm going to talk about in these different processes have generally remained the same, with, of course, some little bits of technical changes. I mean, it is administrative law, so the agencies that are involved change over time. But there hasn't been a remarkable wholesale change where all of a sudden these have disappeared or just come into existence. So I think for now we're just going to assume that these are going to continue to exist in some form. But of course, the devil is in the details, and it could change on how the agencies enforce the rules behind these. Could be more requirements, could be less requirements. So we'll try to keep everyone up to date on that as we can once we know what's going to go on. All right, I'd like to kind of set up the players here, because we're dealing with not just one agency, one court, one area of the country. This is a national area of law, and we have lots of different agencies involved in this type of work. So, and everything in immigration tends to go by an acronym, so it's worse, if not as bad, as the military. So I put them down in an acronym. Let me explain what each one of these agencies are. And I think having a little knowledge of what these agencies do is going to help you, whether you're a hiring HR person or a manager looking to hire talent, just to kind of get a general idea of, okay, who's involved, who am I going to be dealing with, what are the different steps. So let's go through them. USCIS. U.S. Citizenship and Immigration Services. They're the benefit side of the Department of Homeland Security. So they're the ones that will, if you file a petition to get a worker in, to get a family member in for asylum, different various areas, basically a benefit to be able to work or live in the United States, they tend to be the primary agency that's doing that. U.S. Customs and Border Protection, otherwise known as CBP, those are the individuals in the blue shirts that you see when you come in on a flight or on a cruise ship, or even when you're crossing a land border port. They are sort of the gatekeepers of the country, and they're deciding who gets in, when they get in, and how they get in. And they have quite a bit of authority on that issue. Basically, they are the final say. They also do not only passenger, so people with visas, they also do materials, but we won't be speaking about that area of customs law today. We're just talking about people at this point. ICE, Immigration and Customs Enforcement. As I say, those are the guys with the guns, but Customs also has guns, but these are the interior enforcement officers. They're the ones that will go around, they'll do the I-9 inspections to make sure that employers are complying with the I-9 rules, to say that their workforce is authorized to work in the United States. They're also the ones that would go and get anybody if the government wants to remove somebody from the United States for various different infractions, immigration, criminal, customs, various other things. They're the ones that actually will go and get people and keep them in detention until some decision is made on them, whether they're going to be allowed to stay in the United States or they're going to be asked to leave. DOS, Department of State, they run the embassies and consulates and missions across the U.S. that people have to go to get visas. And we're going to go through the difference between a visa and a different form called an I-94 in just a second. But Department of State is the outside the U.S. agency that's deciding who's going to be allowed to ask permission to come to the border. Then Customs will decide who actually gets in the United States, and then ICE, if they want to get you out, will be the people. So it kind of trickles down from there. But Department of State, they're also involved in other different sorts of diplomatic missions, such as exchange programs, cultural programs that they'll support, and there's also visas for those. Those are fairly specialized. We won't be getting into those today, but it's good to be slightly aware of what's going on there. DOL, Department of Labor. Believe it or not, Department of Labor is involved in U.S. immigration law in that they are charged with trying to enforce the rules to say that if a company is going to hire a foreign national permanently, that the U.S. workforce is protected. So they're making decisions on did this employer prove that there's no U.S. workers that can fill this position so that we can get a green card for this person? Are they paying a fair wage to like an H1B worker so that this employer is not unfairly depressing or growing wages that could affect somehow the U.S. workforce? So believe it or not, Department of Labor is involved. So combine these different agencies and see some of their logos on that. Adds a lot of complexity to what we do because we're working with different agencies at different stages and at different levels, and it can be confusing. So hopefully as we go through this, you'll get a little bit better idea of how these different agencies are involved at certain points in this process. Okay, I also like to kind of give, because I think this is confusing, especially if you're in HR and working on I-9s, or you're looking at hiring somebody and they show you a document, or what am I looking at? What am I dealing with? Or if you're in compliance, or if you're just outside dealing with vendors and trying to figure out what kind of documents they have, if you can deal with them. There's different ones, and they mean different things. So the I-94, and the I-94, I guess on your screen, if I'm looking at it right, would be in the upper right-hand column. So it's the one that's starting off with sample, and it has a 742, etc., 9-digit number. Now these have become electronic for the most part. Some of the paper ones are still issued, but this is what Customs gives you, or USCIS gives you, to say how long you can stay in the United States and in what capacity you can be in the United States. So on this I-94, they'll put your class of admission, the date of admission, the place of admission, and the duration of your admission. So the one on here, they were admitted in Seattle. They were admitted on September 13th, 1991, and they're admitted in the B1 category, and they can stay in the United States until July 10th, 1993. And the B1, we'll get to that in just a second, is a visitor category. So that's going to restrict what that person can do while they're here in the United States. Right below that, you'll see a template for what an actual visa looks like. So the visa is sort of, I always like try to explain it as the ticket to come to the United States. It's the government's ticket. It's not the plane ticket. It's not the boat ticket. But it's the U.S. government's ticket to say, okay, you can come now to the border and ask permission to seek entry into the United States. And they obviously have a bunch of different information on there. The individual passport, expirations, if there's any restrictions on the visa, how many times the visa can be used, etc. Then in the, I guess it'd be left-hand corner, that is, there's different versions of it, but that's an admission stamp. So when you come to U.S. Customs and they inspect you, they ask you questions, and they decide if they're going to let you into the United States, they'll stamp your passport with a visa stamp, and then they'll also issue you the I-94. So all three of these documents, although they're separate and we're often involved, all mean different things. And I won't digress too much, but for those watching today, a reminder, if you're not aware, there is a difference, because this is confusing, a difference between the I-94 and the visa. So if somebody's admitted for a certain amount of time, they can stay in the United States and do whatever that admission classification allows for the duration that they were admitted, even if their visa expired. Because remember, the visa is just to get to the border of the United States. It doesn't really have any effect once you're inside the United States, and that can be confusing because people say, well, can I stay here because my visa expired? I look at their I-94, be it paper or electronic, and that's where I decide to tell people, yes, you can stay here or not. I'm not concerned about their visa at that point of the question. Now, if they say I want to travel, then it flips over and I say, well, what kind of visa do you have? Is it still expired? Or is it still valid? Has it expired? What classification is it in? So they're different documents, but they can all be related. So let's go through what we call non-immigrant categories. So today we'll kind of go primarily through the non-immigrant because that's what most people are going to be dealing with, but we'll also talk about the immigrant. The non-immigrant, when I say that term, means you're limited in how long and what you can do in the United States. So there's a classification, a letter that's associated with what you can do, and there's usually a time limit for how long you can be admitted into the United States. An immigrant is, let's, for simplicity's sake, say that's pretty much you're a permanent resident, you're a green card. There's other classifications, but most people, if they're dealing with an immigrant visa or immigrant petition, means a green card, a permanent resident type situation. So let's go through the non-immigrant, because these there's many different categories, and I'd like to just kind of give you a surface knowledge of what they are, so that if you're speaking with an employee or a job applicant or, like I said, just a business colleague, you can kind of understand what their limitations are, and that might impact your business dealings with them. They went through the alphabet, it's pretty simple, and just assigned each letter, and now they've gotten into double letters, a classification, and then they've decided through the years what each classification means. One of the most common is the B. So there's a B1, which is a business tourist, and a B2, which is a pleasure tourist. You can get a visa that's a B1/B2. You might get just a B. It varies, and there's usually, if they let you in one class, you're not prevented from just, if you're allowed as a business visitor, you can also go to Disney World if you would like. But really the main thing with the business tourist category to remember is you're only allowed to do certain things. So you have to be, let's say, a tourist. It's a little confusing with business tourism, but they're sort of the same. So you can engage in commercial transactions. You can be buying or selling something as long as that does not involve gainful employment. So what sort of situation is that, Ben? Well, if you were from France and you wanted to come to the United States to buy a new steel processing machine for your plant in France, you could come to the United States as a tourist, a business tourist, buy that machine from a company in the United States, get a tour of their plant maybe, speak with the engineers who are going to build it for you, give them your specifications, and then you fly home from France and await, or to France and await delivery of that product. We obviously want to promote commerce, so we're going to let people come to the United States to do that. You can similarly come here to negotiate a contract on behalf of your business or what have you, consulting with business associates. So you can come and meet with, if you're part of an international company, you can come to the United States for short durations to attend meetings at your company. Or if there's a potential investor, you could come to the United States and meet with them for a short term in the United States. You can come to the United States, and if you're involved in litigation, not as a working lawyer, but if you are a witness to something or an expert, you could potentially come to the United States and be involved in some sort of lawsuit. You can participate in certain scientific, educational, professional, or business conventions, conferences, seminars. You're not supposed to be, if you're getting paid for that involvement, that can get tricky. Again, this isn't supposed to allow employment while you're in the United States, but you can certainly come to Las Vegas for a trade show if you're from Germany and go to the trade show for 3 days and then fly back. And what's tricky with this category is always that gray line between, well, what's work and what's business tourism. It's kind of a smell test. It's kind of a gut instinct test. There's some guidance, sort of what we have here. When in doubt, always consult with your immigration attorney. But the main thing is, if it seems like the person will be working here, I'm going to come to the United States and I'm going to manage a project for 3 weeks. That might be work. So maybe that B1 category isn't going to allow that. So now where you're actually going in, doing productive employment just as something similar that a U.S. worker would be hired to do. I think that should give you the clue that maybe you're crossing the line and falling out of that B1 category. Another area that's very common, especially when you're dealing with people from Europe, and as well as many other countries, they keep on adding, is the visa waiver program. People sometimes think it's a separate than a business tourist visa, but really it's a tourist visa without getting the actual visa itself. So they're waiving the actual process of going in and getting a physical visa glued into your passport, but you still can only engage in those activities which are allowed under the B category. So coming to meetings, meeting with colleagues, buying something that's going to be delivered to you overseas, selling something that's going to be produced outside of the United States, and where all the benefit of that sale is going to somebody, the financial benefit is going to a company outside of the United States. We allow this program so that people can jump on a plane essentially from countries that we feel are friends with their passport and a return trip ticket that shows that they're leaving within 90 days of entry, and it makes travel very easy. Now they've added what's called the ESTA program, which is sort of a brief background check. You have to put in your information, and if you clear almost instantaneously. And then while you're flying over from wherever you're coming from, Customs is verifying with the plane manifest that you've cleared ESTA. They'll check that at the gate, and to make sure that you've complied with that little bit of a background check. This is one area that certainly could be expanded under the new administration, but we'll have to wait and see. So that's a tourist visa. The H1B visa is probably the most common one that is used for workers. It's kind of what we call the professionals visa. Engineers, economists, lawyers, doctors, IT workers, quantitative analysts, basically any job that requires some sort of specialized degree, professional degree, a bachelor's or higher, and is in a narrow field of study. Trick with H1B is there's some jobs that don't qualify. A lot of sales jobs, a lot of just general business won't, because you can become a salesperson without necessarily having to go to college. Now that's becoming less common, and a lot of times we can argue that this type of sales job or marketing job is highly specialized, and you need a master's and some sort of business degree for that. But that's one thing to always consider is, does this job really require some sort of narrow, relatively narrow, can be 3 or 4, whatever, different degrees, but it just can't be, can't be just an associate's degree or just, well, anything, and, has a degree in basket weaving, that's all that's needed. So a professional degree. Thing to keep in mind is there's a limited number of these issued per year. They're done by federal fiscal year. There's 85,000 slots. So if you're dealing with somebody who hasn't had an H-1B before, and generally it's within the past 6 years, H-1B should come into, cap should come into your mind and think, do I need to get a cap slot for this person? We call it a cap because there's a limit, there's a high end. When 85,000 is gone for the federal fiscal year, that's it for the federal fiscal year. Except there are some individuals and some employers which are cap exempt. So if you're a doctor and you have one of these specialty, we'll call them a J1 waiver, and work in an underserved area, obviously it's very technical, and either you kind of know right away what that is or don't worry about it, but there's this type of individual will be exempt from this type of cap. Universities, certain research institutions are also exempt from this cap. They can hire H-1B workers at any time. But something to be aware of. You just can't go and file it any time of the year. Again, something to speak with your immigration attorney about. Another thing to be aware of with the H-1B is this is where the Department of Labor gets involved. So we have to show that H-1B workers are being paid the required wage for the area, which I'll try to sum it up is the higher of what the government says through its wage surveys or through a private wage survey is sort of the average paid to this type of worker with this type of background doing these type of things versus what the employer is paying other similarly employed workers with the same background. So the idea is to make sure that H-1B workers aren't, use the vernacular, cheap foreign labor. And that can be, there's different levels, but also at this point, I just want to make you aware when you're hiring an H-1B person or looking at them, you have to think, geez, is the salary I'm offering them going to be within this required wage? Do I need to do a little research? Because you just don't want to make a job offer without having looked at what could be the required wage, because you might have to go back and either give them more money or you may have overpaid, which is fine, but just to be aware of it, just something to be aware of. And also with the H-1B, there's also a requirement that every employer maintain various public access files. So the idea behind it is if somebody wants to walk off the street and say, I want to see your public access file for this H-1B worker, that's an enforcement tool that will allow members of the public to go in and make sure an H-1B employer is paying the required wage, so it's not depressing wages for U.S. workers, essentially. Again, something to be aware of if you want to get into the business of employing H-1B workers or not. Definitely something to be aware of. It's not horrible, but again, this is an area that could easily be changed with through the new administration and require different types of materials in the compliance file, different steps towards compliance. I think that will be one of the areas that we'll definitely be looking at. There's the L1 category. That's for multinational managers and transferees. There's really 3 categories. Executives, pretty clear cut. Managers, but have to be senior level managers, meaning that they're either managing other professionals or that they're managing a key department, division, section of a company, and that they're making high-level decisions, that they're more of a decision maker almost than a doer. They're deciding processes, procedures, practices instead of just going out and doing it themselves, and that can be pretty confusing, but something we have to look at. There's also an even more confusing category called specialized knowledge, and that has several different amorphous definitions, but basically you need to show that someone has, a foreign worker has some sort of advanced or unique knowledge about something that they're doing at an affiliated company overseas, and that you want to bring that information to and knowledge to the United States because it doesn't exist here. That's what the L1. Now, transferee implies that there's some sort of a transfer, and what that means is in order to qualify for the L1, that person that you're looking to transfer has to have worked for a foreign, so a non-U.S. parent, subsidiary, affiliate, branch, company that's legally affiliated with the U.S. company, and that there's this transfer of people between back and forth. And they've had to have filled one of these categories while working for at least a year in that overseas company. And this is fairly common, especially with large companies where we're constantly transferring VPs and managers and what have you. It's a nice way to be able to bring people in and out of the United States that way. There's the E-visa. And there's different types of E-visas. And again, the E doesn't mean anything. It's just where they landed on the alphabet when they finally got to this category. There's the E1, a treaty trader. There's the E2, treaty investor. So the E requires that the individual or the company that's seeking to get the visa classification is a citizen of a country that has signed a trade or investment treaty with the United States. So France, Germany, Australia, I don't want to go to because I'll forget. There's so many of them, but not every country. So you just, that's one thing to keep in mind right away if you're looking at E. Do we have a treaty with this country, a trade and commerce treaty? Then am I engaged in substantial trade or am I engaged in substantial investment? The E can be used either for the trader or individual himself or herself. If usually it's a smaller operation, I am the person that invested the money, or I am the person managing the trade with my little company. Or you can be the employee of a larger company that has either made the investment or is engaged in the trade. Thing to remember with that is the employee also has to have the same nationality that qualifies the operation, the enterprise, to get a visa. So if you're looking to transfer somebody from France under the French Trade and Commerce visa, double check to make sure, or treaty, make sure that they're also a citizen of France. So you can't use the E to transfer an Argentinian employee because they're not of the same nationality, and that can trip up people. So something to be aware of. 78 countries, and the trade must be substantial, meaning that a majority of the trade that this company, this U.S. company that's petitioning, is involving the country of nationality that's qualifying the enterprise. So they look at, okay, well, if you're from France and you want to get an E from France, how much trade are you doing with France? And you have to show a majority of your trade, international trade, is with France. The investor is a sliding scale. There isn't a set amount, but they look at what type, how much is the usual investment for this type of business. If it's a big manufacturing company, maybe it would normally take $20 million to start a new steel processing plant in Wisconsin. So they'll say, okay, well, if it's 20, then you have to invest 15, maybe $15 million in order to qualify. And again, it's up to the consulate officer. Or if it's a smaller business, maybe you just want to do a service business. You do teaching in a certain area, and you want to create a company that teaches different people or does presentations for this. So normally that would only cost $20,000 because you're not really investing in machines, but you're investing in marketing and maybe some facilities and uniforms or what have you. So maybe you only have to invest $10,000 or $15,000. So it can be less. I've gotten people for millions of dollars, and I've gotten people in on the E for probably under 10,000 or around 10,000. So something to be aware of with that. The O is what we sometimes call the walk-on water. So these are Nobel Prize laureates, winners, but more typically, there's somebody that has really wowed their field of science or medicine or business or art And they have become an individual of national acclaim. So they're published, they're reviewed in articles, they've won prizes, awards, distinctions. They're making upstanding contributions to their field. When you think about the field, they're one of the top couple people in the world that comes to mind when you're thinking about this particular area. Most common in the sciences and medicine, but certainly can be in other fields. NAFTA, TN, again, possibly on the chopping block coming up. But not only is NAFTA a trade in physical items treaty, but it's also a person trade, if you allow, treaty, in that it created categories that people can enter the United States to engage in business. So there's a slightly varied business visitor category under NAFTA that allows for a little more slack on the B level than what the B provides, and some deference to what a person says is supposed to be kind of taken at face value, more so under the treaty. But it also allows a certain set of listed professionals, and not all of these are super high level. They can be adjusters in various fields and other things, so they not have to be, a chemist or a super scientist or anything. But to get under NAFTA, you have to be have a job in one of these categories. Then it also says in the treaty what the person has to have: a certain type of degree, a certain amount of training or experience, or a combination, or either or on that. And then, as you might expect, NAFTA is limited to Canadian and Mexican citizens. So if somebody's a German working in Mexico and maybe has a temporary visa to work in Mexico, that won't allow them to get a NAFTA TN category because they're not a Mexican citizen and they're not a Canadian. But it's a very useful category in that it has, one, allows for quick transfer, but also relatively easy, where individuals just have to go to the border with essentially a job offer, proof of their credentials that meet their NAFTA requirements, and they can enter the same day. So that's for Canadians. For Mexicans, it's slightly more difficult in that they have to go to a U.S. consulate or embassy and apply for a TN visa, but you don't have to pre-apply with USCIS in the U.S. So again, it's typically much faster because we were allowed to skip a step, even with the Mexican citizens, to do that. So that's a nice category to deal with. All right, so those, and there's certainly more categories out there. There's P's and U's and A's and basically every letter of the alphabet. But if you're working at a company, those are really probably what you're going to run into a majority of the time. So, again, just give you an idea of what might be required and some of the restrictions on what you can do with these different types. But I also like to cover towards the end here the different types of green card applications, because the natural progression, once you get somebody in your workforce on one of these non-immigrant visas, the United States is obviously the best country in the world, and they will want to stay here often. So how do I get them to stay here permanently? That requires a whole separate process. That's the permanent residency, commonly called the green card process. And as you might imagine, the government, just like it did with the non-immigrant, has chopped the different kinds of immigrant categories into different subcategories. So I'd like to kind of give you, again, a broad overview of each of those sub-immigrant visa categories so that you might be aware when you're speaking with people or planning your business what you might have to do to get somebody a green card, permanent residence status through this process. So somewhat similar to the O, very similar to the O, is the extraordinary ability. They break these down into EB, employment-based. There's 1, 2, 3, 4, 5. So we're starting with the top, EB1. These are sort of the, call them premier workers. And the premier of the premier is the extraordinary ability. So these, again, are the Nobel Prize people, the Walk on Water people, won every prize and award, are on every committee. Magazine articles are written about them. These are amazing people in their area, and there's different categories you have to show, different that they've made, 3 of 7 or 4 of 7 different types of accomplishments to get that. Then there's also outstanding professors and researchers. This is sort of somebody who's slightly less than extraordinary, but still pretty darn amazing and smart, in that you're showing that they're going to be working either in sort of a professorial, a advanced education type capacity, or that they're engaging in research for a research institution. So there's a little bit less of the categories that have to be met than they would in extraordinary, but still showing that this person is really amazing in their area. And then managers and executives, so these are sort of the L1 to L1As. So, obviously executive speaks for itself, but then also the senior level managers that are either managing people or some sort of department, division, category of the company that's important to the operations. And with the manager executives, you would have to show, as with the L1, that they also had a similar role with a legally affiliated company overseas, a branch, affiliate, subsidiary. What's nice about these categories is, and we're going to get to this in the end, you don't have to go through this process of labor certification, which really adds a lot more hoops to jump through. So if we can, we try to fit people into this premier category, EB1. Right below that are the EB2s, which are advanced degree or exceptional ability, which I guess might be slightly less than extraordinary, slightly less than outstanding, but still nonetheless really good. So this is for positions, and it's not just that the individual has qualifications, but that the position being offered requires either a master's degree or a bachelor's degree and 5 years experience. It can be an either or, say, well, I'll take a master's or a bachelor's in 5, or you can just say, no, I only require a master's, or I only require a bachelor's in 5 degree. So it's a little bit of a combination of one of those. More and more jobs are filling in as, obviously the education requirement for almost all professional positions continues to rise. More and more jobs are falling into this EB2. There's also the national interest waiver. This is if you can show what you do is somehow important to the entire United States. You've created some new cancer treatment, or you're going to create the next green energy innovation. And so it's just super important to all the citizens of the United States to have you in the United States. You can petition to get one of these national interest waivers. The other one is the exceptional ability, which again is probably sort of the sub of the other two higher categories, but you're still pretty darn good. Labor certification is required for just a couple of those. The national interest waiver is exempt from that. The professional, which is the most common, this is your average engineer, IT person, scientist. That's a job that requires a bachelor's degree and less than 5 years experience. There's also another little category under that where you just need 2 years of training, but both of those will follow into this EB3 category. This is where you have to show that there's no U.S. workers to fill the position before you can file the petition to give the person their green card. And that process of showing there's no U.S. workers is called labor certification. So what is labor certification? So something you want to be aware of if you're looking at and you're negotiating with an employee and they're like, well, I want you to hire me. I've been on H1B for a couple years. I know that's going to run out. and I want you to sponsor me for my green card. Something to be aware of. To get to that point, you're going to have to show that there's no U.S. workers available for that. Well, that seems like a big task, so how do I do that? Well, that's where the Department of Labor gets involved. The Department of Labor has set up a system whereby employers must go through certain steps and show certain things to prove to the Department of Labor that there's no U.S. workers who are willing, available, or qualified or interested in filling that position. And U.S. workers, just to be very general about it, is basically permanent residents, U.S. citizens, and other people who have some category that allows them to work permanently in the United States without having to get special sponsorship from a particular employer or family member. So DOL says, okay, you have to go through these steps, and if you get through these steps and either no U.S. workers apply, or you can show that any U.S. worker who applied didn't meet the minimum qualifications for that position, then we'll certify, and you have to show also that the worker is qualified for it that you're trying to sponsor, then we'll certify that you can't find anyone. You can take that certification then to USCIS and try to get one of those categories that we just spoke about that requires this perm labor certification. It's a minimally qualified standard, so be aware of it. You can't just say, well, nobody else is qualified for this because the person I have is just the best. They have the exact requirements. The Department of Labor has said no. What we want to show is you have to show there's no U.S. workers who have just enough competence and ability to perform the job in a competent manner. Not the best, but sort of just at the qualifications. This can be tricky in, how do I pare it down? I really want to just hire this individual, but it's something you have to keep in mind. And again, when you're assessing it, will I be able to show this? What do I think the current labor force is showing in my area? If I run the required steps for this, am I going to get flooded with qualified U.S. applicants? Again, something to think about, and with timing, talk with your immigration attorney about these different steps. Go over it. Again, there's obviously anything with the immigration, there's a lot of complicated steps, but something to keep in mind is you're going to have to do certain recruitment. You're going to have to put out to the public that you're looking to fill this job in order to try to elicit any qualified, willing, available U.S. workers to assess whether they're qualified or not. So you have to place what's called a job order with the state workforce development agency of the place of employment. You have to do postings within your company saying that you're hiring. Some of them require wage information. You have to put that out. Typically requires 2 Sunday print ads. Labor certifications are one of the few areas that you'll see actually still advertised in the Sunday newspaper. So it's slightly interesting going through the Sunday newspaper because I can tell that almost all of the ads in the professional category of the Sunday newspaper are people trying to get through the perm process for those individuals. So, and then the employer is allowed to pick 3 other recruitment steps from a list that they have. Often it's the company website, careers page, through a professional journal, headhunter/recruiter, employee incentive program. So you have to go through these steps, document that you did these steps, and then show the results before you can get the labor certification. So again, something to be aware of. There's too much there to go into in just an hour, and then also to just remember after today's talk. But if you're looking at doing this for an employee, or even like, well, if I hire this person and they want a green card, what am I going to have to do? Hopefully this kind of gives you an idea. I mean, we get through them a lot of the times. We never know until we run the ads if people are going to show up or not, or if they're going to be qualified or not. But a lot of times, as the hiring person, what it's been like to try to fill this job. And probably if you're going through this process means that you've already determined it's really hard to hire a U.S. worker to fill this job. In the last few minutes here, I'd like to also just kind of go through a little area that isn't anything necessarily maybe that you could do about, but to be aware of because it's going to impact the people that you're working with. The U.S. has divided these immigrant visa categories into different levels, not only on the EB-1, 2, 3, 4, 5, but also they've said we're only going to allow so many people from certain countries into the U.S. Per year. So they've taken all the countries, they've divided them up with the different categories, and by birth said, okay, well, we'll let 7,000 people born in India get into the EB-1 category and 7,000 people in the EB-2 to get into the U.S. per year. So why this is important is certain countries have sent so many people, or so many people from those countries already in line to get one of these immigrant visa slots that are issued sort of like the H1B cap on a federal fiscal year. There's already so many people in line that to get to the front of that line, it's going to take multiple years. So what we're looking at with trying to get people a green card from India, I can get through the labor certification in probably less than a year. We can get to the second stage, which is called the I-140. But then we're stuck until one of these immigrant visa slots becomes current. In other words, has the person that you're working with moved sufficiently to the front of the line where they're ready to get one of these annual slots? And right now it's taking, well, at least 7, 8, 9, 10. There's estimates it may take 10 to 20 years, even in some of these upper categories, for certain countries to get to the front of the line to get one of these visas. So how that may impact you is, one, dealing with disappointment maybe on a personal level with the individual, but then also realizing you may have to continue to extend that person's non-immigrant working visa multiple times as you're waiting many, many, many years to get the person through the green card process. Their place in line is set by when you started their green card process. So a perm, if a perm is necessary, or the I-140 if the I-140 is the first step, because your category allows you to skip the perm step, but that sets when the person's in line. Some categories, if they're from Norway and they're a multinational manager, there's not an excess of people from Norway looking to come to the U.S. as a multinational manager. They can go through the process just as fast as you can get through the process. There's no special wait time to get one of these visas. But it can really add some planning and complication to that. And then, as we sort of touched at the beginning, there's also the enforcement side. And so this isn't an I-9 talk, because I'd be happy to do that sometime, and I do that fairly regularly. But something to be aware of. The reason that we're going through all these hoops is so that we can get the right documents to be able to complete the Form I-9. And the Form I-9, as probably many of you know, but if you're not aware, that's the document that we've all been deputized as employers to complete and to maintain and to monitor on behalf of the federal government to make sure that our U.S. workforce is authorized to work in the United States. And they just the other day, want to make people on this presentation aware, issued a brand new I-9. You can get it at uscis.gov. Look for I-9. That new I-9 is going to have to be in use by January 22nd, 2017. And it's kind of a nice change, I think, although we're still absorbing it. But that new I-9 has now a little more space on it, so you can fill in stuff for those of you that have to work with H1B portability and OPT extensions. There's space on the form now instead of squishing it into the margins. There's also drop downs that will go into different categories for certain sections. And important to note, this is an electronic I-9 in that it's not a commercial product that you can complete from start to end, and that you can have signed electronically or what have you. This is sort of a pre-fill form that you will then have to print out and have original signatures on. But I think most people are going to want to go and do this online. It's going to require, you have a terminal available to you when you're doing the I-9 process. But the nice thing is it's going to have little reminders on there. If you miss a step or if you jump a step, it's going to give you like a twinkling light. I haven't seen it in action yet, but it will give you some sort of warning that something's been missed. And also these drop-down categories are going to hopefully end some of the confusion on what do I call certain documents. Do I say DHS? Do I say USCIS? Do I say U.S. government? Is it Social Security? Is it Social Security Administration? I mean, you know, you can imagine 1,000 different ways, and those that have dealt with I-9s will know that that's always been kind of a bothersome area to deal with. So be aware of that, you know, and be prepared for it. Tell people you work with, but also, you know, the I-9s, you want to make sure at a minimum that you have a valid I-9 on file and updated for every current employee in your workforce. You have to retain the I-9s for a certain, there's a formula, 3-for-1 formula for employees who have been terminated or that have departed, that you have to maintain that I-9 for a certain period afterwards. But you know, the main thing is if you know you have I-9s and you look at them at least once a year and you make sure that you're comfortable with that you have complete I-9s and that you have an I-9 on file for every current employee, you know, that's at least a really good start. And then after that, you want to go through and make sure that you have all the information correct, that you're not missing any expirations on any documents that expire, and that you that are employment authorization oriented. You know, reminder, if someone's identity document has expired but it was valid when you complete an I-9, you don't redo that part. So if you complete an I-9 with somebody's current driver's license, you don't go back and re-verify their I-9 just because their driver's license expired. That doesn't have anything to do with proof that their authorization, that they have authorization to work. Again, we'll leave that for another day to go through all the I-9s, but this is how it all ties together. You want to make sure that if somebody's able to work from you because they've gone through and have one of these categories, or if they have a green card, that you also have a current I-9 on file for that individual. So I thank you very much, and I'll see if anyone in the audience today has any questions, or if there's any questions online. Be happy to address those. Okay. Okay, as I kind of expected, have you heard if there's going to be any major changes with the non-immigrant categories, for example, now that Trump will be in power? Again, I think it's sort of an unknown. He certainly talked about quick action in the removal area. I think one of the other areas, obviously, that we're going to see a lot of it is the I-9, which we just spoke about, probably an increase of what's called the E-Verify, which is the electronic online verification program for employment authorization, which doesn't do away with the I-9, but it's a complement to the I-9. And I think we can probably also expect some changes in, like with the H1B possibly, as to what we might have to go through to get an H1B worker. There's been talk about increased fees for certain employers, which already has been changed over the years. Then we might have to show some sort of maybe mini labor test, additional posting, something like that. So again, I don't think that there's any talk, because they're useful, of just doing away with any of these categories, but the real trick will be how is the agency going to evolve, and what sort of new regulations might be forced to get people one of these categories. And then, okay, general employment. If we don't want to sponsor someone for a non-immigrant visa, such as an H1B, who has applied for a position opening, do we have to sponsor them? The answer in general is no. An employer is not forced to sponsor an H1B worker. H1B workers are not protected workers. You can't discriminate nationality or citizenship just because they are Lithuanian or German or, you know, Icelandic, but you don't have to spend the money and the time to sponsor an H1B if you don't want to. So the short answer is you don't have to. Obviously contact your immigration attorney if this is somebody you want to, or if you want to have some sort of policy put into place to limit your sponsorship. There are a few hurdles to be aware of with that. And looks like the last question that we can get to, and again another general employment one, which is, what can I ask a job applicant about their immigration status? The Office of Special Counsel, which is a Department of Justice beast, that enforces laws protecting against discrimination related to immigration status or citizenship status, has said the basic two questions that you can ask are you authorized to work in the United States, yes or no? And a question that's along the lines of, will you now or in the future need sponsorship from X company, our company, to work in the United States? And then that will elicit what you might have to do to hire on the person. But so you can't, at least at the initial stage, go into extensive detail and ask about U.S. citizenship status, or are you a permanent resident? It's restricted down to basically, are you authorized to work in the United States, and will you need me as an employer to sponsor you? And then it goes from there. So be cautious with that, and certainly consult your labor or immigration law firm about how to move forward with that. So, well, I hope that gave you a good overview of the different areas that are commonly encountered with business-based immigration law. And certainly if you have any questions or concerns, we're more than happy to speak with you about any of those areas, or with I-9, especially with the probability of increased enforcement in that action. We'd love to sit down and talk to you about what you're doing now, and maybe some ways that we can improve that going forward. So thank you very much.